Ms. Hany.
Mr. Speaker, I rise in support of this bill which aims to enhance support for aspiring as well as existing parents with young children to better manage their work and family commitments as our nation moves towards building a society that is made for families. In July 2021, the PAP Women's Wing and Young PAP jointly presented a paper on women's development. Titled Take Action for Women in Singapore, it was drafted based on our engagements with over 1,500 people comprising different age groups and backgrounds who were surveyed on issues faced by women in schools, workplaces, and home. One recommendation which I resonate with, and more particularly so currently as an expectant working mother in my third trimester, and of which I've been advocating for during the white paper debate on Singapore's women development in April last year, is to further encourage equal sharing of childcare responsibilities amongst mothers and fathers. Something that we have aimed to achieve since as early as 1961, when the Women's Charter was first enacted. Section 46 of the Act specifically sets out that upon the solemnization of marriage, the husband and the wife shall mutually bound to cooperate with each other in caring and providing for the children, and the husband and wife shall have equal rights in the running of the matrimonial household. Increasingly so, fathers are playing a more active and significant role in caring for their children, from bringing their kids for medical appointments to walking them to and back from school. My Woodgrove residents have often shared with me that the role of a father has been expanding, and this is keenly felt within each family. Many more fathers have also been seen doing so, signifying a change in public attitude towards the sharing of parental responsibility. Notwithstanding, the rebalancing exercise sought to be undertaken by this bill should also be accompanied by a re-examination of the support given by the state in order to ensure that it remains fair to our children, mothers, fathers, and not to forget the employers. I therefore applaud the additional enhancements which will be introduced through this amendment bill, such as the increment of government-paid paternity leave and other benefits. Nevertheless, I wish to take this opportunity to seek several clarifications and make several suggestions. Firstly, providing parents with the flexibility to decide how to share their parental leave. This was one of the recommendations set out in our Women's Development Recommendation paper. Currently, a working mother can share up to 4 weeks of her 16-week maternity leave with her husband. With the increment of the government-paid paternity leave or benefit from 2 to 4 weeks, I wish to take this opportunity to seek clarifications if couples will still be able to enjoy this flexibility of enabling the working mother to apportion up to 4 weeks of her maternity leave with her husband, such that her husband can have up to 2 months of paternity leave to support his wife and their newborn child. In relation to this, I would further urge the government to consider providing full flexibility to all couples to decide how they wish to share their maternity and paternity leave between themselves. Through my many interactions with the young parents that I've met in Woodgrove during our Embracing Parenthood team community engagements, as well as during my house visits, I have realized that there is no one-size-fits-all solutions for parental leave arrangements. Every family has its own unique set of circumstances and preferences. Some mummies may prefer to have their husband to play a more supportive and active role after childbirth, as they look forward to resuming work sooner, while others would much prefer their maternity leave to be extended further so that they can fully concentrate on their newfound state of motherhood, nursing their children and being present for significant milestones before returning to work. My second point pertains to clarifications on the period of a female employee commencing her government-paid maternity leave. Under the bill, female employees may only commence their maternity leave no earlier than 28 days before childbirth. However, we have seen cases where expectant mothers have had to be warded for more than 28 days from their estimated or actual delivery date, or were intermittently required to go on medical leave for treatment even before their child was delivered due to pregnancy complications. In such situations, the working mothers had to rely on their own paid or unpaid medical leaves as they were still considered ineligible for government-paid maternity leave. Mr. Speaker, the current debate presents an opportunity for us to further improve the support measures given to aspiring and current parents. On this note, I would like to ask whether MSF would consider additional amendments that will allow some flexibility on the commencement date of the maternity leave for those medically certified cases. For example, instead of a continuous period of no earlier than 28 days from the date of confinement, could expectant mothers be given an aggregate 28 days of government-paid maternity leave that may be consumed in their final trimester? Or, while all medical appointments are important and necessary, there are some which are straightforward and of which will not take the full working day. For situations such as this, could the bill perhaps provide for the flexibility of the time off and or half-day consumption of such leave days? My third point pertains to the readjustment of child development account restrictions to include other child-related expenses. When I attended Woodgrove's Bonding with Your Child Day just yesterday, alongside with 80 of my Woodgrove residents with young children at an indoor activity playground theme park, I took the opportunity to gather more feedback about the challenges faced by our young parents. One common reply was the concern over rising inflation and increased cost of living. They shared that while they appreciate our local community's effort in cushioning such impacts, they also hope that more flexibility can be exercised on how monies in this child development account can be utilised. For example, monies in their child's CDA can be utilised to pay for preschool fees, but not the optional extracurricular activities organised by the preschools. Although many parents still see the need to enroll their kids for these optional activities to prevent them from losing out. Doing so would require the parents to pay out of their own pocket an amount ranging from a few $100s to several thousands of dollars per month, as they are not allowed to tap on their CDA funds. Fourth point is in relation to the introductions of family care leave. In a recent focus group discussion which I co-organized in my capacity as the head of policy for PAP Women's Wing, one resounding feedback gathered from over 70 participants was a consensus call for the introductions of family care leave in order to provide some flexibility for Singaporeans to deal with various family issues that may crop up from time to time. These issues will of course vary from household to household. For example, managing the effects of postpartum depression for mummies, accompanying toddlers for speech therapy sessions, or attending to the medical needs of aging parents or relatives, and etc. The fifth point and my final clarifications pertains to employers' buy-in. While we strive to achieve conditions that will better support Singaporeans to embrace family, I'm also mindful that we must take care to ensure that employers' interests are not forsaken, as this will ultimately affect the livelihood of the employees. To this end, can MSF share, based on the feedback that they have gathered from its various engagements conducted with employers, what are some of the issues that employers have been facing or expected to face in this regard, and whether such concerns were shared with their employees so as to arrive at a win-win outcome? Mr. Speaker, it is my belief that these suggestions, if implemented with the endorsements of the employers, will address the evolving needs of every Singaporean while they play their part to support their families, further reinforcing the notion that Singapore is made for families. In conclusion, notwithstanding the clarifications and suggestions I've raised earlier, I stand in support of this amendment bill.